Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 21-5073. Gordon M. Price versus Merrick B. Garland in his official capacity as Attorney General of the United States of America, et al. Mr. Busa for the appellants, Mr. Korn-Revere for the appellate.
Mr. Busa, good morning. Please proceed.
Good morning, and may it please the court, Joe Busa on behalf of the government. The statute governing commercial filming on National Park Service lands serves important government interests and is fully consistent with the First Amendment. That statute imposes the same kind of permit and fee requirements that apply to all commercial activity on NPS land. Commercial activity of all stripes is tightly controlled on park land to ensure that our national park system serves its core statutory purpose of preserving nature and wildlife unimpaired for future generations. That is a risk-averse mandate and one that NPS takes very seriously. For commercial activity to be allowed in our parks, it must not risk harm to the park's core purpose as parks and must give the public.
This is First Amendment protected commercial activity, right? This is a First Amendment case. The argument is that this commercial activity is protected by the First Amendment. So how the government deals with other non-First Amendment protected commercial activities doesn't really relate to this case, does it?
So first of all, we don't dispute that filming in general is an expressive activity, Your Honor, but it is important to recognize the broad suite of commercial regulations at issue here because it shows that the government really is targeting commercial conduct. It is not written a specific set of regulations, specifically targeting First Amendment protected activity.
I don't think you need intent to prove a First Amendment case, do you?
No, of course not, Your Honor, and we're not saying that. But I think the key point.
Let me just ask you a straightforward question about this to be sure I understand it. Okay.
Mm-hmm.
The location fee. There's two fees, right? A location fee and a cost recovery fee. Is that the way it works?
Correct, Your Honor.
Okay.
Yes.
And under the statute and the regulations, the location fee is that what you get your permit for? Is that the way that works? That's what you pay for the permit.
Commercial filmers have to pay both the location fee and cost recovery fee, if any, in order to obtain a permit and be able to commercially film on it.
Okay, I understand it. And under the statute and the regs, the location fee is independent of it's in addition to the cost recovery fee, right?
Correct, Your Honor.
Now, the cost recovery fee, it's through that the Park Service recovers all of the expenses for managing the filming, correct? Like guards, cleanup, whatever they have, right? And
that's correct.
The location fees on top of that, right?
Yes, Your Honor.
So why isn't it just a classic and unconstitutional fee on the exercise of a First Amendment right? I mean, why isn't it like Murdoch and these other cases? It's a fee for a First Amendment protected activity. The location fee has nothing to do with cost recovery. It's the cost recovery fee that does that. So why isn't that just a simple tax on a First Amendment activity?
Because it's a broad-based assessment on all such.
Suppose I don't agree with you about that. Suppose I don't agree with you that because this is commercial activity, it's covered by it's no different from any of the other commercial regulations that control commercial activity. Suppose I think that this is different because it's First Amendment. Then isn't it a fee for the exercise of First Amendment activity?
No, Your Honor. I think that's foreclosed by Leathers versus Medlock, where there similarly there was a broad-based assessment. There was a sales tax assessed on cable providers. The court recognized that was First Amendment activity. They were engaged in speech, but the court said there was no problem from assessing that tax on cable providers and, by the way, exempting newspapers because there was nothing in that broad general scheme regulating commercial activity that in any way was disproportionate separate as to anyone's content or ideas or ability to communicate any messages. The Supreme Court said many times in Minneapolis Star, Leathers versus Medlock, Arkansas Writers Project, that a broad-based tax like that is wholly constitutional. And this tax is no different than the taxes similarly assessed on all commercial activity of all stripes. Hot dog vendors, people selling communicative t-shirts, people engaging in filming, people seeking to install rights of way or telecommunications equipment, which again also might implicate First Amendment values. All of these things are just of one piece of a broad-based commercial regulation. And for that reason, we say there's no First Amendment problem with the tax. Second, and apart from that, Your Honor, I'm sorry.
And what's your reaction to Price's argument that this interim guidance that was issued after the district court's decision undermines the government's claim that that this fee is necessary to protect government's interest in protecting the parks? That is the low impact exemption.
The interim guidance, Your Honor, is a second best fallback position that we issued in order to comply with the overbroad injunction here. We do not.
If we were to reverse the district court, you would revoke the interim guidance?
I would want to consult with my agency partners before giving a definitive answer. I suspect that might be the case because we would have an obligation to continue enforcing the statute as Congress wrote it in order to provide the best protection for our national treasures.
That's a really good point. I was going to ask you about that. Okay. I understand your answer. That's fine. Thank you.
But the key point about the guidance, Your Honor, is that it really is a second best fallback position. And the statute at issue here, 100-905 in Title 54, really is part of a broader series of regulations, as the guidance itself shows. So 100-751A is the core general power of the Secretary to regulate the use and management of NPS lands. That is the source of authority to regulate all types of commercial activities on NPS property. It was the source of authority that NPS used before 2000 to require permits for commercial filming, and before 1946 to require location fees. And no one doubts that what happened in 2000 was not a standalone regulation of speech, but Congress supervising the Secretary's use of that authority and disagreeing with a certain discretionary decision not to collect location fees. It's not a standalone regulation of speech. It is Congress amending a specific application of a general power. Congress must have that authority to supervise an administrative agency's exercise of its discretion. And in doing so, I don't think anyone should conclude that Congress defangs its own power to do so by having, written a statute that mentions filming specifically. The same effect could have been achieved by just writing a broad-based statute, as Congress already did in 100-751A.
So, counsel, in your briefs, you argued also that the government is acting as a proprietor here. And is that independent of or anterior to the point you're making now?
I think it's independent, Your Honor. Congress created the national park system and directed NPS to maintain it in such a way as to maintain it unimpaired for all future generations. So Congress has given us a directive about how we're supposed to manage these lands. And that's a risk-averse directive. We're entitled to guard against even small risks that can come from any commercial activity on the property. And that's a proprietary function. We're managing these parks in a certain way that has nothing to do with speech or anyone's ability to communicate publicly. And it's also important to recognize that what's happening here is not a use of government property as a forum to communicate on the forum. Haig, Schneider, Perry, Cornelius, all of the canonical public forum cases talk about using the forum to communicate with other people on the forum, but that's not at all what's going on here. This case is really no different from if a film editing studio wanted to set up shop on the National Mall. No one would think that because the mall can be used for political demonstrations or any other type of gathering, that somehow the major film studio would gain a leg up in the First Amendment analysis. Quite the contrary.
Let's think about how good the fit is here. The distinction between commercial and non-commercial. filming. Now, all the visitors to the park, with few exceptions, have a video capability in their pocket. Sorry, my video keeps going out. I'm not sure why. It's almost impossible, it seems to me, to know whether filming activity is ultimately going to be part of a commercial exhibition, or whether it's simply people making films for themselves. So it seems that the fit is less obvious now.
I don't think that's quite right, Your Honor, and that's because of how we've designed the regulations here. So the regulations focus on whether the person engaging in the commercial filming activity intends to earn income from a market audience at the moment of filming. And so we've included that intent requirement specifically to avoid a post hoc trap, where it just so happens that, look, you engaged in the filming activity at the time in good faith, not thinking you're going to earn money, and then later on decide maybe you want to commercialize it. We're not going to go ahead and penalize you retroactively. That's a benefit to the filmer. But it's certainly true that anyone going on to NPS lands planning to make money from the film that they're making, knows in advance that that's what they're going to do, and they need to obtain the permit. And just to highlight, I'm sorry, Anna, I didn't want to cut you off.
A person who comes to the park with her iPhone, and she has a YouTube channel. I think that's what they use, where she has she makes money through commercials, and she's filming to put this on her YouTube channel, and she's just standing there with her iPhone doing that. She has to get a permit, pay a location fee, right?
That's correct, Your Honor.
So
Yes.
How do you distinguish this case from Boardley?
So in Boardley, Your Honor, the demonstrations in question could only take place in certain designated areas. There, by and large, talking about parking lots next to visitors centers, and the people were merely engaging in speech. And this court said, look, if you have a small group of people just talking in a small designated area next to a visitor center, that's indistinguishable from a normal park visit. And so, so you
just have one person with an iPhone. I mean, what's the possible governmental interest? There's no costs. There's no impact on the park. In fact, if you have two people, they're both standing there with their iPhones. They're both filming exactly the same thing. One's going to send the film to his mother, and the other's going to put it on their commercial YouTube channel. One needs a permit, and the other doesn't.
That's correct, Your Honor. And so just a couple of responses. First, NPS's statutory mandate is a very risk-averse mandate, right? The agency is entitled to guard against even small risks to the unimpaired future use of generations. And so,
what's the risk in the case, in the hypothetical I gave you? What's the risk?
So it may be that in a specific case, there actually is ultimately no risk, but there's actually no way for the filmer to know that before they come to us and tell us what their activity is going to be.
Doesn't the government have to be especially careful because this is a First Amendment activity?
And the government has been.
It's a classically overbroad statute.
What about the copycat risk? I would think in this day and time, every time somebody puts something on YouTube, 1 million people do the same thing with a slight variation.
That's exactly right, Your Honor. And there is a concern that, one influencer goes into, one sensitive area during wildflower season, and then suddenly you have a stampede of similar people doing similar things. And moreover, these filmers can't be expected.
That could happen if she sends it to her mother. The mother could send it to the whole family, and you could have a stampede of cousins looking at the wildflowers.
That's possible, Your Honor, but the commercial motivation here is something to take into account. I mean, people motivated by the intent to earn money can be expected to put boundaries in ways that's not true for normal visitors. Moreover, NPS, I'm sorry, I don't mean to be interrupting anybody. Moreover, NPS is used to the activities of normal visitors, and they know where to position their resources to guard against the harms to the parks that can come from those visits. But, a commercial filmer we have no idea in general what they might be intending to do. And they have no idea whether their even small boots on the ground might have particular effects. As the secretary noted in 2013, when promulgating the regulations at issue here, although small groups can be expected to have far smaller consequences, that's not zero. And we need to know whether there's any particular risks. There's certain times and places that can have congestion, where there's nesting issues or delicate wildlife or plants or flowers that the filmer would have no reason to know about, but we wouldn't. All we're saying with the permit requirement is, come tell us what you're going to do. And by the way, small group.
What you just said is equally true of the non-commercial filmer. They don't know what your constraints are, what they might be trampling on by accident. That doesn't make much of a distinction. It seems to me that once you have everybody armed with a camera, some with commercial intent and some not, that you're really deprived that the damage to the park rationale is vastly undercut, but it leaves standing your return on the government's investment argument, right? That they want to recover their costs, and one way to do that is to charge commercial users.
That's exactly right, Your Honor. So one reason for the permit requirement in that circumstance would be so that the public can obtain a fair return for the private exploitation of public resources. But I do just want to highlight that, non-commercial filming is not, it doesn't go unregulated here. As we pointed out in our briefings, the other side does not dispute a personal filming incidental to a normal visit does not require a permit, but any sort of filming that could threaten park resources does require a permit. And so it actually is true that, a personal visitor to a national park that engages in some kind of activity sort of outside the normal, what you would expect from a normal park visit, would actually have to obtain a permit if that filming could be expected in any way to risk harm to our national parks, in the exact same way as a commercial filmer can risk harm when they're pursuing their pursuit of income from the filming activity.
All right, so we're running over time here, but I don't want to miss out on your response to the overbreadth argument that I guess really we don't have the district court. Well, I'll let you articulate it, but it seemed to me your argument was that the district court really didn't delve at all into the degree of overbreadth, if any, as an empirical matter.
That's correct, Your Honor. And the district court had no basis for concluding that, any hypothetical small group filming activity on a public forum, and here we're just talking about, the National Mall, Lafayette Park, a handful of areas within the NPS system, that hypothetical small group commercial filming activities there are so substantial in relation to the vast swaths of NPS land on which everyone agrees we actually could apply these requirements lawfully. That's so substantial that the harsh medicine and last resort of facial overbreadth doctrine is warranted. The Supreme Court made clear in Williams that you can't resort to facial overbreadth to invalidate an act of Congress on its face in all of its applications on the mere basis of a hypothetical. And that's what we have here, Your Honor.
All right, if there are no more questions, we'll give you a couple minutes to reply. Mr. Korn-Revere.
Thank you.
Thank you, Your Honors, and may it please the court. I represent Mr. Price. And let me start with the points that Judge Tatel was asking about at the outset, whether or not this really is similar to the other kinds of commercial restrictions that exist in national parks. And I think that is the incorrect premise from which the government's argument flows. The flawed premise is that this is materially identical to other statutes and regulations that govern other commercial uses, but this is completely unlike things like cattle grazing, mining operations, permanent or semi-permanent occupations of federal land. Permits for commercial filming grant no right to occupy federal land. They simply allow people to do the same thing that other visitors to the park are free to do. And this is illustrated by the hypotheticals that Mr. Busey uses. He referred to one in his argument, but there are several in his reply brief. saying that this would be like setting up a sitcom writer's room on NPS property, or building a film editing operation, or operating a kiosk on the Yorktown National Battlefield. That's the opposite of what we're suggesting. And as a matter of fact, as we pointed out on page 26 of our brief, that in sharp contrast to the types of cases that the government cites, Mr. Price was not occupying federal land to engage in commercial transactions, such as selling Blu-rays of Crawford Road from a kiosk or operating a drive-in theater at Yorktown National Battlefield. As I say, he was seeking access to federal land only to the same extent as non-commercial filmmakers and commercial film crews. There's simply no analog to this broader suite of regulations to which Mr. Busa refers. There aren't amateur cattle grazers on federal land or hobbyist hot dog vendors. The relevant distinction here is the semi-permanent or permanent occupation of federal land and not commercial motive. As a consequence,
would you, I'm sorry, go ahead, Bob.
Well, I was just going to say, if there's a broader suite of regulations that applies, it's really the organizing statute 100-101 that the government, that the director of operations referred to in his memorandum on the interim rules, suggesting this is the regulation that governs use of the park generally, that protects the resources, rather than the commercial uses that Mr. Busa argues is the analog.
The government says at one point in its reply brief that there are, quote, many circumstances that plaintiffs concede would present no constitutional difficulties. What are those?
Well, that was a misstatement of our position. That was simply quoting, I believe, language from Forsyth County versus Nationalist Movement, talking about how in overbreadth challenges, you're allowed to challenge rules or laws, where there are many applications that wouldn't present problems. There are some that do. We haven't conceded that there are applications of this law, written as it is, that present no difficulties. What we've argued is that the law is overly broad and imposes unconstitutional tax. I think
would you see any problem at all if any First Amendment problem if the government had simply applied the rules it has for the press to commercial filmmakers? Would that be okay?
Well, yes, because it would be fine, because there's no permit requirement and there's no fee.
Right. Okay.
And as a matter of fact, I think this is conceded by the government, not in its argument today, but in the application and the adoption of the interim guidelines, when it suggests that there is no requirement, and risk averse or not, for low impact filming, where you have 5 people or less with handheld equipment and a tripod, which describes the situation that initiated this case. And in the discussion in the memorandum adopting the interim rules, the government explains the reason for this. It says, in recent years, NPS has seen an increase in low impact filming activities within park areas. These activities involve minimal equipment and crews, such as individuals or small groups that film using smartphones or other handheld devices, in many cases with nothing more than a tripod for equipment. These types of productions are highly unlikely to need a permit because potential for impacts to resources and the visitor experience is no greater than the potential for impacts from visitors engaged in casual filming. This is true whether or not the footage is used for commercial purposes, such as posting footage online for profit. The commercial motivation adds absolutely nothing to the government's interest. In First Amendment terms, the Supreme Court has made clear for decades that having a commercial motivation does not diminish the level of First Amendment protection. And in terms of whether or not having a commercial motive affects the government's interest here, it is ironic that the government itself hosts photo contests. That's the brief for the amici National Press Photographers Association pointed out at page 9 of its brief, that it hosts annually a Share the Experience photo contest. I visited the website for that contest over the weekend and discovered to my surprise that they offer a $10,000 first prize for winning that contest. So if commercial motivation is what undermines the government's asserted interest, it is ironic indeed that the National Park Service would sponsor a contest seeking to attract people to the park. The commercial distinction established in the current law serves.
You haven't addressed the government's argument based on simple return on their investment if in commercial activity, which strikes me as being quite independent of any damage claims and the damage claims. The argument based on damage, as I said to your friend on the other side, is very much weakened, I think, by what you just read, for one thing. But that leaves standing this question of whether they can't just charge for use of their property and try to recover from those who are exploiting it for commercial gain.
Right. I think the interim guidelines do take out the government's position entirely on the issue of the permit requirement and how that can be applied. As to the fee requirement, I think the line of cases beginning with Murdoch versus Pennsylvania responds to that entirely, that the First Amendment does not permit the government to charge a fee for the exercise of First Amendment rights.
So you can put a sales tax on newspaper sales, right? As long as it's a sales tax that's on everything.
As long as it's a generally applicable tax. But this isn't a tax. This is a fee for exercising First Amendment rights on federal property. Also, it's a content-based fee.
I mean, of course, it's levied as a fee. How is that why is that important in terms of the word tax versus fee? So what?
Well, because in the cases that the government cites, like Atlanta Constitution, Journal and Constitution versus the Atlanta Airport, we're talking about, again, occupation of a space from which to sell newspapers. And that is a rental fee, the government operating in its proprietary capacity. Here, the government is operating a park where it allows everyone to come in and spend time in the park. And it simply charges some users who exercise their First Amendment rights where it doesn't charge others. This isn't a single in kind fee that applies to everybody. Certain speakers are singled out and charge a particular fee. Now, Mr. Busa says that this
no, it doesn't apply to everybody. It applies to a category called commercial activity.
It applies to a category of people who are called commercial filmmakers, but not all commercial filmmakers.
It's all commercial activity. It's not just filmmakers.
Except it exempts news uses, which is also a category of commercial filmers, which the government recognizes.
Right. Now, so what do you do with the point made by the government in their brief that there are innumerable statutes that exempt news functions for long established good and sufficient reason?
There are certain benefits that have been authorized because the government or the courts have recognized for a long time that there's a difference between a subsidy and a tax. Subsidizing a First Amendment activity is permitted, as in Regan versus taxation with representation, or the government is not required to subsidize First Amendment activity in that case.
Isn't the exception for news something like a subsidy for news gathering?
The difference is you can't go to jail or have to pay a fine if you, in the case of a subsidy. But here, if you don't go along with the government scheme that separates speakers from others, you stand the risk of being imprisoned, as Mr. Price was facing that.
But the statutes that the government cited are by and large exemptions, just like this one, where some burden is not made applicable to news gathering.
Right, but as Mr. Busa was discussing in his appearance a few minutes ago, he's citing cases like Leathers versus Medlock, which placed a tax some on cable television and not on newspapers. He mentions Arkansas Writers Project, but that's the more applicable case where you have a different tax based on the type of magazine you're talking about. Some magazines being charged a tax and others not. The Supreme Court said that that was unconstitutional. Here, you have irrational distinctions between current news and documentaries. Some are charged a fee, others not. And the regulations that were adopted pursuant to the law expressly show favoritism towards some kinds of speech. For example, in section 10905A2, it provides that the secretary may include other factors in determining the appropriate fee as the secretary considers necessary. Now, in the legislative history, it was explained that the bill authorizes the secretary to reduce fees if the activity provides clear educational benefits for the department and would exempt from any fees newsreels, television news productions, and some commercial photography. The guidelines that have been adopted pursuant to the statute and the legislative history have expressly favored some content over the others, as we explained at page 26 of our brief, that the superintendent has reduced or waived fees for projects that the National Park Service considers benefits NPS based on the amount of value that NPS receives. It says that they may receive significant benefits from production considered to be human interest or travelogue segments filmed in parks. The benefits can include educational information on park programs, public awareness, and park-specific programs or constituency building. So the level of discretion is built into the fee structure from the statute and through the regulations. And the Supreme Court in Forsyth County versus the Nationalist Movement said that that level of discretion in setting fees is sufficient to render the law unconstitutional on its face. And that's precisely what we have here. We have now, with the interim regulations, which eliminates both the fee requirement and the permit requirement for low impact filming, recognition that how that doesn't really serve any government interest whatsoever.
You're citing that for that proposition, right? I mean, this interim regulation doesn't really help you in your argument, right? Because the statute still exists, correct? We still have the statute. I mean, the statute, I guess you could make a pretty good argument that the interim regulations violate the statute, don't you think? The statute doesn't authorize an exemption like this.
No, the statute does not authorize
Right,
this.
yeah. You're citing this for their statement that you're citing this for their statement that low impact productions are unlikely, right, to need a permit because they're no more impactful than anything else like that.
That's right.
That's what you're studying it just for that sentence. Yes.
Well, there's no, yes, specifically to your question, but there is no greater impact based on the commercial versus non-commercial distinction. And in setting the fee, in making the commercial versus non-commercial distinction, both the statute as it exists and the regulations adopted by the Park Service have discriminated between different speakers, and it's a content-based distinction, and the level of discretion all make that unconstitutional.
Counsel, in an overbreadth case, I'm not sure why we have one here, since you've conceded that your argument applies to the entire park, basically. I'm not sure why we don't have an as-applied challenge, but putting that aside, or maybe you can address it. In an overbreadth case, the district court's supposed to determine whether there's a substantial overbreadth. Right? And what do we know? What is there in the record to inform that judgment?
Well, I think that the record here stands very much the way it did in Boardley versus the United States. And that Boardley said that it wasn't necessary to look at all of national park property and all of public forums. And then footnote 3 says that traditional public forums may exist in parks, but there isn't a record to say which ones exist. What we know from Boardley is that these regulations are overly broad because they do apply in both traditional and designated public forums, wherever they may be in national parks. And that makes it overbroad. And it's also overbroad because of the filmers that it applies to, even the low impact filmers that present no conceivable threat to public property.
If the degree of commercial filming, which is the subject to this regulation, is essentially minuscule, several times a year, somebody comes in to film commercially and maybe they seek a permit, maybe they don't. If that's the case, and we don't seem to know, then we ought not to be invalidating the statute in its entirety.
Well, I think this is addressed in the legislative history to Public Law 106-206, the 2000 enactment that enacted fees, where it talked about something, the magnitude of applications that have been submitted over the years.
Well, I won't give you my extended reasons for not caring about legislative history, but I don't. It wasn't enacted. It may have been in there as a compromise because they couldn't get it enacted. Who knows?
But it does, just as a factual matter, address the extent of filming activities on public lands and indicates the reason for the enactment. And what it comes down to, essentially, is that Congress wanted a piece of the action. There's no indication that this was necessary to protect public lands. And we know from the interim regulations that it really isn't, and that it's an overbroad way of doing it. But they saw Hollywood productions like Dances with Wolves and said, we should be able to collect on some of the proceeds. That legislative judgment.
Reasonable. The way you just stated that seems eminently reasonable.
Well, it may be for the larger productions, but for the now range of people who come to the park, many of whom simply use handheld devices, and some of whom may post on YouTube, then it's staggeringly overbroad, because you're talking about thousands upon thousands of park visitors who impose no potential adverse impact on the land, who are nonetheless facing the possibility of prosecution and being fined simply because they pulled out their smartphone. And they have a YouTube channel.
But they're not doing anything. Those people are by and large not doing anything with a commercial intent, correct?
They may or may not. And Mr.
There are millions, I don't know how many millions of visitors to the parks. Acadia National Park, with which I'm familiar, has about 3 or 4 million visitors a year, and it's, I think, the smallest park. In any event, the percentage of people filming there for some commercial purposes is inevitably tiny.
In which case, the potential impact on the park doesn't justify putting people in jail.
Isn't your point that this would be unconstitutional if there was just one person?
Well, that's right. I mean, if the law imposes an unconstitutional burden on a person who's engaging in.
But the Supreme Court cases always talk about a substantial overbreadth, not one person.
But the substantial overbreadth here applies both in terms of the scope of the regulations on all areas within the parks. And by the way, let me just say one thing about that. It isn't restricted to just public forum areas. Section 10905C talks about still photography, and it says people are free to take pictures wherever the public is allowed access in the parks. And they only requires permits if there are going to be props or models being used. And that was a part of the law that was undisturbed. But it basically says that people have a right to take photographs wherever they go in the parks. It isn't just the public forum areas.
Where does it say that?
This is section 10905C, which basically says that except as provided in paragraph 2, the secretary shall not require a permit or access fee for still photography in a system unit if the photography takes place where members of the public are generally allowed. Again, it's not focused on just public forum areas or designated public forum areas. It says people simply have the ability to take photos for either commercial or non-commercial purposes whenever they are in places where people are allowed to go. And the amicus brief, the National Press.
This case is about filming, not about photographs.
Well, yes, it is. And this provision C was expressly excluded by the district court, but it indicates that the interests that the government is talking about aren't affected by whether or not something is commercial or non-commercial. Commercial still photography is permitted. Commercial filming is not, and it's irrational, as discussed in the amicus brief of the National Press Photographers Association at page 22, where they say that the difference between a film and a still photography is irrelevant with today's equipment, where you simply flip a button. At one moment you're violating the law, at the other moment you're not. And yet the government is claiming that there's some vital interest that requires making people into federal criminals if they press one button but not another. The law is staggeringly overbroad in its reach in restricting what areas require a permit, and it imposes an unconstitutional tax as in violation of long-standing Supreme Court precedent like Murdoch versus Pennsylvania.
All right, if there are no more questions, then Mr. Busa will give you 2 minutes.
Thank you, Your Honor. I have several important points to make. First, there was a lot of focus on the interim guidance. And I want to make very clear that the language that my friend on the other side has focused on in that guidance, where it says that, that smaller, low impact filming activities are unlikely to need a permit. I want to make very clear, this is not NPS saying that there is no risk and that we don't need permits for small filming activities. This is all downstream of the price decision. This entire memo from page 1 says that it's dealing with the price decision. It's trying to craft interim guidance that will comply with the price decision. And, it is still the case that Congress has created a risk minimizing regulatory framework here for NPS, that NPS is entitled to at least require commercial filmers to come to us and say what they're going to do, because they don't know that what they're going to do is going to have a big impact or not, depending on specific conditions and their specific proposed activities. And that's the necessity for a permit requirement, even for small groups. My friend on the other side said that, filming is actually different from other commercial activities we regulate. And that's just really not true. I mean, we regulate commercial tour operators who don't physically occupy the space they don't rent it in the same way, but they certainly use NPS land in the same way that a commercial filmer does. Ditto with a small-time hot dog vendor carrying a sack of hot dogs rather than setting up a kiosk. I mean, all of these things are commercial activities we're entitled to regulate. It has nothing to do with permanently occupying federal land or not. Finally, as for, there's been a lot of discussion about small-time filming activities. And what's important to focus on here is that Mr. Price's filming activities involve 4 people, 2 observers, a tripod, a mic, and physically occupying federal land for an extended period of time. That's different in kind from a normal park visit. It is not incidental to most filming. And, the hypothetical application to a single person commercially filming on a public forum is so far afield that it does not warrant the harsh medicine of facial overbreadth here. Thank you, Your Honor. Yes, okay. I'm sorry.
So you objected to the nationwide injunction.
Yes, Your Honor.
Yeah, but in a case like this, where the standing of the plaintiff is based upon the effect of the regulations on people other than the plaintiff himself, how can that possibly be limited to the relief that you would give in an as-applied case?
Because in every circumstance, the Article 3 power extends only to granting as much relief as is necessary to give full relief to the plaintiff, but not to non-parties. That's just a fundamental.
You're saying that the overbreadth doctrine of the Supreme Court, which is, of course, it's of its own making, it's not to be found in Article 3, is unconstitutional.
No, Your Honor, we're absolutely not saying that. We're saying that the overbreadth rule is a merits rule, just like all facial review is a rule for determining whether the plaintiff in their own case in controversy has prevailed on the merits. But no one thinks, I'm sorry, Your Honor.
Can you cite one case? I mean, you cite a bunch of cases here on the preliminary injunction thing, but none of them are First Amendment facial cases, facial challenges under the First Amendment. I don't know of any case that is held that when if a statute is unconstitutional, the court limits its injunction to the plaintiff who brought the case. Do you know of a case like that?
I'm sorry, Your Honor. I think I would have to flip it the other way around and say I'm actually not aware of a case from this court of
Well, why
Supreme
don't
Court
you start by answering my question?
No, I'm sorry, Your Honor. So just to be clear, I don't know of a case that fairly addressed.
Do you know of a case where the court invalidates a statute on First Amendment grounds and limits the relief to the plaintiff who brought the case? That's all. That's my question.
I don't think I'm aware of a case from this court or the Supreme Court holding that after having addressed the issue as being teed up by the litigants, Your Honor. But to be clear, I'm actually not aware of a case, and I realize I'm over time, just one final point on this. I'm not aware of a case in which this court, the Supreme Court, has held that because you prevail on a facial challenge, you therefore get a nationwide injunction protecting non-parties to the case. That's antithetical.
Doesn't the court just declare the law unconstitutional?
You can conclude that
isn't that a declaratory judgment that the law is unconstitutional is the equivalent of an injunction, isn't it?
We have often treated a declaratory judgment as the equivalent of an injunction. That's correct, Your Honor. But all I think technically the declaratory judgment does is ensure that the specific litigant wouldn't have to litigate the merits of that issue again.
I have no further questions. Thank you. Yeah.
Thank you, Your Honor.
All right, gentlemen, your case is submitted, and Madam Clerk, if you'd call the next case.
Judge Henderson,
Yes.
I will be back in 1 moment. 1 minute. Don't wait for me, please.
All right, Madam Clerk.
Case number 21-1097 et al. Jane Doe petitioner versus Securities and Exchange Commission. Mr. McCoby for the petitioner, Ms. Wagner for the respondent.
All right, Mr. Maccabee, please proceed.
Thank you. May it please the court, Max Maccabee on behalf of petitioners. Good morning to everybody. Your Honor, petitioners appeal the Securities and Exchange Commission's denial of whistleblower awards for the Novartis $25 million bribery settlement. Several years ago, the commission settled with Novartis for $25 million based on Novartis' self-reported findings of bribing doctors to prescribe their pharmaceutical products, and the bribes were accomplished through travel and event planning. And when the settlement was finished, the commission invited whistleblowers to submit award applications under their whistleblower award eligibility regulations, which is a lead-to test. Did the whistleblower provide any original information that led to the successful $25 million settlement? Original information in the regulations is information not publicly known, but can include news articles relevant here, so long as the applicant.
Can I go back to what you argue in your brief? Your argument in the brief is, as I understand it, is that the SEC erred here because it limited whistleblower claims to the 3 circumstances listed in the regulation, in the rule, right? That's your argument.
2 arguments. One is that, the other is we actually fit into one of the 3 fact patterns, but yes.
Well, the commission says, let's start with your first one. And you're arguing that this rule is clear, right? Because it didn't use the word only. That's
correct.
Argument, right?
That's correct.
But it also doesn't use the word, it doesn't say among others or including. So you could really interpret this either way. Is that your only argument, that it's clear? Is that the word only is not there? I just don't understand why that makes it clear. It seems to me the language which says, it says in any of the following circumstances. Now, it doesn't say only in those, nor does it say in any of the following circumstances among others. So we just don't know, right?
That's what we contend, Your Honor. And if the commission had intended only, it would have said only. And we highlighted very carefully the August of 2020 Securities and Exchange Commission order, which said that that language does not expressly state that the 3 components it was led to. That was their agency position until this litigation. And one of the arguments we make is we asked the court not to accord any deference to the fact that
there were several several cases where there's this in the record. There's two more cases. There's one in 2018, and then another in 2020, where the commission did reject whistleblower claims because they didn't fall into one of those three categories, right?
Your Honor, the only case that we're aware of where they actually commented on the meaning of the language, whether it was restrictive or whether it was broader, was this August 13, 2020 order, where it said that it was not, that the language was the textual language, the natural reading, that language did not expressly state that the three components were the only way to establish led to. They concede that. That was their official agency position. Yet they're changing it here during litigation. We ask that they should not be heard to change their position during litigation. But more to the point, a natural reading, we suggest, is not limited. And I think it's as simple as a patron going to a restaurant, and on the menu it says, you can have any of the following. You can have spaghetti marinara, bolognese, or carbonara, any of the following. I think a patron could naturally order buttered spaghetti. But if the menu said no substitutions permitted, or only the following, I think a patron naturally would not order buttered spaghetti instead of marinara or bolognese. I think it's as simple as that, as far as a natural reading of the text. We cited Supreme Court case Townsend v. Sane, and we cited a district court case that said in the following circumstance is not limiting.
Yeah. And
the district court case said if the government wanted it to be limiting, it would have used the word only.
Let me go back to an argument you made earlier. You said there were two arguments. One was, I think, that you said that the commission also erred because it denied your claim under fact pattern 2.
Right.
The commission said you didn't raise that before the commission. And then in your reply brief, you say you did raise it at page, I don't have the page number. You did say you raised it, but you didn't give a citation to where you did raise it. Do you have a cite to where you raised it before the commission?
Yes, we raised it at the very end. So in the appendix, in the final, when we submitted our objection to the preliminary denial, at the very end, the last footnote on that page, we stated we incorporated all of the arguments, all the possible bases on the fact patterns in which to make the claim. So in the first application, we make a claim on everything, and then in the objection to the preliminary denial, we say we incorporate by reference all the arguments made in the initial application.
So you're saying they were before the commissioners?
So
of that?
I'm sorry?
You're saying the argument was therefore before the commissioners in reviewing the initial decision?
Yes. We applied on everything, and the site we understood we properly cited it in the brief, but
well, I didn't see it. There's no citation in the brief. It's not there. That's why I asked you the question.
It's the footnote in the appendix. If you read the appendix and you see that the application and you see the objection to the preliminary denial, you'll see in the objection we incorporate all the arguments made in the original.
My only point is I wouldn't have known that from your brief. That's
okay.
I asked you where it is, so you've now told us.
Okay.
Right, and so the SEC, I don't remember, did they address this in this final decision or only in the preliminary decision?
The waiver, sorry, Your Honor, the waiver issue? Is that the question?
Yes. Did the did the commission in its final decision address that argument about fact pattern 2?
Yes, they did. It did. It did. I found it. So it's note 20 in the final, in the objection, where we incorporate all the arguments we made in the original petition. But yes, the commission did deny on all grounds.
They didn't just say that, they actually dealt with fact pattern 2?
Yes.
Okay.
So on that particular issue, Your Honor, we contend that we did satisfy that subsection 2. The commission's argument boils down to adding language into subsection 2 that's not there. We provided the information to the commission. That's not disputed. It had to, albeit it was about a different company, but we provided it. We submitted that information along with the Wall Street Journal articles that we published. But it was submitted to the commission contemporaneous, and that information was material to the settlement. They admit that in paragraph 17 of their Novartis settlement order. Virtually admit it, that our information was material and led to the settlement because it instituted the internal review by Novartis's counsel and led to the $25 million settlement. So it's highly meritorious and it's deserving. The government tries to distinguish that fact pattern, the second element, by saying, well, the information has to be about that particular company. Well, guess what? We provided that particular company. The word company is not in the text. It is in the subsection 3, but not 2. So that has to be understood as deliberate. And so you can only reach the decision the commission made if you read a word in there that's not there, i.e. that company. It's not there. So we contend
But aren't you overlooking that there's a step here, that is that the company is given an opportunity? And I'll ask Ms. Wagner can address that. You're overlooking that step. I mean, you say something about another company. The statute first says, company, you straighten this out. And if you're reporting on something other than Novartis, that wipes that step out.
Your Honor, oh, sorry. Is my time?
Right. That's all right. I don't need an answer to that. If there are no more questions, then Ms. Wagner, we'll hear from you.
Thank you. Good morning. May it please the court. Brooke Wagner from the Securities and Exchange Commission. Over a decade ago, at Congress's direction and following notice and comment, the Commission promulgated the rule at issue here, Rule 21F4C. At that time, the Commission made clear that the rule required claimants to establish one of the 3 causal circumstances.
Wait. What do you mean made clear? It doesn't say only in the rule. Well, why didn't the Commission just put the word only in there? I mean, it isn't clear. And you can make a very good argument that the Commission knew how to use the word only because it used it in the footnote in the release document, but it didn't. In other words, the Commission knows how to use the word only, knows how to spell it, and knows how to use it, but it didn't put it in the regulation.
Sure.
Pretty hard, and it's pretty hard to say. And also, well, why don't you just answer that question first of all?
Sure. Of course, the rule could have been clearer in that it could have included the word only. And I'll just note that to Mr. McAfee's point, that is all that we acknowledged in the August 2020 order. We acknowledge that it doesn't expressly state that the 3 circumstances are the only way of satisfying the rule. In other words, it doesn't include the word only.
Okay, so this is an ambiguous rule, right? The question is, do we defer, correct?
Well, I think if the court finds it ambiguous, it should defer. I think that even without the word only, I think that there's still the natural reading and the best reading of the rule in context is still that it is limited to the 3 circumstances.
Maybe, but take a look at release. I think it's 89-551, August 2020. it says, the commission says this one didn't satisfy any of the three fact patterns. And then here's what it says in its reasoning. It says, although Rule 21F4C does not expressly state that the three components are the only way to establish it, it has been the commission's consistent practice. I mean, that's a pretty obvious, pretty clear concession by the commission that the rule is not clear, but it's been its practice to limit recoveries to one of the four fact circumstances, right? That's what that says.
It states that it's not expressed, indeed, but it also acknowledges in a footnote, I think, that there's nothing, as you say, there's nothing in the text that is clearly the other way. But
okay,
we're
into ambiguous land, right? Which brings up the question of deference.
Sure.
Right, which the courts since Kaiser are much more subscribed now, correct?
Sure. If we're talking about ambiguity, then we are looking at the guideposts under deference, but as we guideposts under Kaiser. But as we explained in the briefs, the commission's interpretation here would easily satisfy each of those guideposts under Kaiser because it is authoritative, longstanding, consistent, considered, and it implicates the commission's law enforcement expertise and its experience administering the whistleblower program for over a decade.
Okay. Ms. Wagner, I'm just curious about SEC procedures. Are rules like this reviewed by the General Counsel's office before they're issued?
I believe the General Counsel's office is generally involved in rulemaking.
Mm-hmm. Well, I ask because, you know, with the courts being far more skeptical about deference to agency regulations that are ambiguous, it would seem to me that an agency like the SEC would want to do everything it can to make sure its regulations are clear and not ambiguous. And this seems, you know, such an obvious example of a problem that could have been avoided simply by putting the word only in there. That's why I ask whether the General Counsel reviews these things, because I would think anybody looking at this would have said, wait, this is not clear. We need to make it clear so that we don't get into trouble later with the courts. So you don't know whether they're reviewed by the General Counsel's office?
I think they were reviewed by the General Counsel's office.
Well, someone missed it. And I have to say, you know, this has got to be one of the sloppiest regulations I've ever seen. Look, not only is it only not there, but you got three fact patterns. Fact pattern 1 ends with an or, and then it goes on to fact pattern 2.
Yes.
And then fact pattern 2 ends with a period. I mean, I don't mean to be picky about this, but this is what we do. Courts do this sort of thing to try to understand what the agency's doing. And why would the second one not have said or? Is there something significant in that? Are we supposed to look at the third factor as somehow different from the first two?
Candidly, my suspicion is that that's a drafting error because there were originally two circumstances and then the third was added later. But I agree with you.
You need to. I'm only speaking for myself here, but you need to take, at least from me, a message back to the commission that they need to get their act together on these kinds of things. They need to avoid drafting errors at this point, but more importantly, they need to have clarity in their regulations. Otherwise, you're going to have cases like this all the time. And the courts are increasingly skeptical about deferring to agencies' interpretations of these kinds of regulations. So
Understood.
Yeah.
Which I presume in this case long predates the Kaiser decision.
It does.
It does.
Yeah.
Yes,
So
of course.
you've got an inventory of breaks that need some review.
Yeah, it does. But of course, the drafting errors existed then and now.
Of course, we never want drafting errors, of course.
Yeah. Ms. Wagner, counsel for the plaintiff here, petitioner here, said that the the claim that their facts fit into pattern 2 was raised before the commission and addressed by the commission in its final order. I cannot find that in the order and let alone in the petition before the agency. Is it there?
No, it is not there. My understanding, they included a footnote in their objections to the preliminary determination, that purported generally not to waive any position or argument, that didn't raise this argument in particular. It didn't urge it before the commission. And so the commission's order, as you know, it has one paragraph where it notes that the petitioners appear to concede that they have not satisfied any of the three circumstances. And then it proceeds to explain why it's not appropriate to reward them despite not satisfying any of the three circumstances. So the commission didn't rule on the applicability of 21F4C2 here.
Thank you.
All right, we have your argument, Ms. Wagner. If there are no more questions, you just want to rely on your brief.
Yes, exactly. Thank you very much.
All right, thank you. Mr. McAbee, unless you have something, or unless the court has questions for you, I think we have your argument as well.
May I make just a couple points?
All right.
Just quickly, we contend that the subsection 2 was not waived and that the commission did actually deny expressly on C2, C1, C2, and C3. So it says it
All
on
right,
the.
you've already made that point.
Okay.
What else?
And then finally, we urge the court not to give deference. The Kaiser case specifically cites West Virginia Highlands Conservancy, which says that fee applications are well within the bailiwick of courts. It's not anything that, it's not an EPA toxic waste complicated issue that requires agency deference. That is directly on point in this case as to why the court should not accord any deference on this issue. Thank you. We appreciate it.
All right. Madam Clerk, if you'll call the next case.
Case number 21-7033, Vantage Commodities Financial Services 1, LLC, appellant, versus Assured Risk Transfer PCC, LLC, et al. Mr. Gibbons for the appellant, Mr. Dodge for the reinsurer appellees, Mr. St. Genos for the Willies appellees.
All right, Mr. Gibbons, good morning. Please proceed. You need to turn your mic on.
I'm sorry, is it
All
not
right.
on?
Muted.
Oh,
It is now.
Okay. May it please the court, John Gibbons on behalf of Vantage. I would request 2 minutes for rebuttal. Vantage was established as a business to issue credit to energy companies so that they could purchase power and provide it to the public. Vantage protected itself on this credit business by purchasing a quota share credit policy, whereby if there was a loss sustained in the issuance of credit, the quota share credit policy would step in and pay the loss. It was a quota share policy is one in which the limits of liability are proportionally distributed amongst a number of companies. Those companies here are the appellees. Vantage contracted for, agreed to, and paid premiums, including $800,000 for this quota share credit policy. This contractual agreement is documented in a number of different places, but most importantly, in 2 contractual binders that, as the name connotes, bind the parties. Those are binders that were issued by Willis and signed by the Chief Operating Officer of Willis, Vermont. Vantage suffered a loss and under the terms of the policy enforced its right to a $26 million judgment. It then turned to the quota share members who had proportionally agreed to pay the limits, and the quota share members disavowed the contractual agreement and, in an irony, sought to, for a credit insurance transaction, sought to turn the credit insurance policy into an uncreditworthy venture after having collected and pocketed $800,000 in premiums for each of them. Vantage brought the enforcement action here really to take the parties who could be responsible to pay the loss and enforce the judgment. the credit binders, which state that the quota share members will pay on the same terms, conditions, and settlements as the credit policy. And the term settlements is what's most important, because that doesn't mean a compromise, it means a resolution, and a judgment is a settlement. That promise was made and was the basis for Vantage paying premiums. Willis issued those binders, and there are two of them issued before the policy and then 8 months into the policy. That was the promise that was where the value was here. Otherwise, there'd be no value in purchasing the credit policy. Vantage sued for breach of contract against the quota share members, and the district court dismissed our well-pled express contract claim under the ruling that the binder didn't actually make any promise. It simply stated the terms by which the limits would be paid. That is a contract, and binders are in fact enforceable contracts. It was supported by $800,000, and the district court's dismissal of the express contract claim, which the architect of this entire program, a gentleman by the name of Paul Palmer, testified to that the quota share members agreed to. That dismissal of our express contract claim was error. There's nothing that forbids us from making an express contract claim. There's no immunity that is granted to the parties here, the quota share members. They can certainly be held liable for that.
What is
There's also,
Counsel, what is the best single thing to which you can point as either the content or the existence of an actual contract, or express or implied?
well, I think we would point to three things.
Well, I'm looking for the best one.
The binders, but I would also, the binders certainly, per the testimony of Mr. Palmer, contain the agreement, memorialize the agreement. But then we also have supporting that Mr. Palmer's testimony, and we have the admissions of all of the quota share members, including their agreements that they would, they confirmed that they were taking $5 million of $22 million in limits issued by ART to what they call an EDF, which is the parent of Vantage. On summary judgment, the district court determined that the $800,000 of premiums didn't constitute consideration for this payment promise. That's error. The payment of premiums is recognized to be consideration for an agreement. The quota share members can try and dispute that, and that would be factually, and that's really what this disagreement boils down to. But to say that $800,000 in premiums isn't consideration just is contrary to the law of consideration. The district court also issued summary judgment when there were admittedly a myriad of fact disputes in the case. The appellees identified, I think, 150 to 100 paragraphs of fact disputes. They relied upon 454 paragraphs of statements of material fact. We disputed, I think, 125 of those paragraphs or more. The material fact disputes were robust in this case. In fact, the appellees recognized that they were so robust that they moved to strike our facts, and the district court sat as the ultimate fact finder and dismissed our claim without acknowledging or addressing our evidence. With respect to Willis, the district court dismissed our negligent misrepresentation claim against Willis on a ground that Willis didn't even raise or argue for negligent misrepresentation because it doesn't apply. The economic loss doctrine was not argued for a negligent misrepresentation claim because that's a purely economic tort. Willis does not attempt to defend the district court's ruling. Instead, Willis asks this court to uphold the district court's ruling on an alternative ground by making this court the first fact finder. Well, the entire point of our appeal,
even, excuse me, I think I'm right. Even if you're right about that you didn't have notice, I think you have to show prejudice, don't you?
Well, Your Honor, I think that certainly
What-
the fact that,
And you don't say anything about prejudice in your brief.
well, we certainly say that the economic loss doctrine doesn't apply to negligent
I know, but
misrepresentation.
you have to go on and the court won't reverse that unless you can show prejudice, and you didn't indicate in the brief what sort of prejudice you suffered. So,
Well, the prejudice that
I
we
mean,
suffered, Your
you may
Honor-
have. My only point is it isn't in your brief.
Well, I apologize, Your Honor, the prejudice that we suffered is that an argument has now been raised by the.
But you
district court.
understand why I asked the question, right? I mean, I'm right. It's not in the brief, right? You agree with
I
that,
don't-
which means, well,
I
did I
don't-
miss it? Did I miss it?
Well, I don't think
Or
we
is
call it prejudice, Your Honor, but I think
Mm-hmm.
that the application of an argument that we weren't able to respond to that isn't applicable is the prejudice. I mean, I think that by saying that, in fact, the economic loss doctrine doesn't apply to negligent misrepresentation and applying it and not letting us have that, that argument is the prejudice. So we didn't
Yeah.
call it prejudice, Your Honor, but we certainly addressed the point that that is prejudicial, not being able to address the fact that it doesn't apply.
Mhm.
And it shouldn't have been entered as a basis to dismiss us and preclude us from the jury trial. Now, I mean, more to the point, the entire argument about the economic loss doctrine, Your Honor, is it doesn't properly apply the Witt and the Aguilar decisions, which find special relationship for precisely this type of issue where Willis, this type of issue where Willis has made money in performing a business duty, and now having done so allegedly negligently or wrongly, according to the quota share members, to then walk away and attempt to not have any liability to the extent that Vantage suffers loss. The DC Court of Appeals called that perverse and said, and put the Witt and Aguilar special relationship exception to the economic loss doctrine into the law. And I see that my time is nearly up, so I would like to reserve
All right,
some-
thank you. We'll give you a couple minutes in reply. Mr. Dodge.
Yes, good morning. May it please the court. I'm Rich Dodge on behalf of the reinsurer appellees, and I plan to address appellant's arguments for overturning the district court's well-reasoned and thorough decisions. And if there is to be a theme for this appeal, and which we've heard in the opening, it would be that an appellant doesn't make it so by saying so. An appellant is required to identify actual facts that were improperly disregarded by the district judge or that were material. Vantage, our appellant here, is simply providing its own narrative, completely divorced from and unsupported by the facts on the record. And doing so does not reasonably create a material dispute of fact. Wild allegations and hopeful legal conclusions do not warrant a jury trial. Indeed, the arrangement at the heart of this appeal is not unusual. It is a traditional insurance and reinsurance relationship. Vantage purchased insurance directly from ART, a captive insurer licensed in DC. ART separately contracted with the reinsurers for them to reinsure ART for any covered losses for which ART was liable. And these were very sophisticated parties, businesses working on these transactions. Agreements document these relationships. But what is highly unusual here is an insured pushing past its insurer to allege breaches of a direct contract and an implied contract against reinsurers without having had any contact with them whatsoever. The district court correctly granted reinsurers' motion to dismiss and denied Vantage leave to amend, and correctly granted summary judgment in favor of the reinsurers. So I'll go through these decisions. First, in its August 2018 decision, the district court correctly recognized that because Vantage was not a party to the reinsurance agreements, Vantage could not claim the benefit of those terms. Then, as the district court found in its November 2018 decision, Neither of the credit insurance binders issued by ART to Vantage were contracts between the reinsurers and Vantage. The district court was correct that the binders simply disclose the existence of the reinsurance policy, but that description alone does not create a contractual relationship with the reinsurer defendants. The district judge correctly concluded Vantage's alleged direct contract claim with reinsurers was not plausible. And in its March 2021 decision, the district court correctly granted summary judgment for the reinsurers on Vantage's implied contract, promissory estoppel, and unjust enrichment claims. The undisputed facts show that prior to Vantage obtaining a money judgment against ART in 2016, Vantage and the reinsurers never corresponded directly or transacted any business. They had no contact whatsoever. Indeed, Vantage submitted its claim to ART, the insurer, its proof of loss of that claim to ART, and arbitrated its claim with ART. Vantage never contacted or involved the reinsurers, confirming Vantage's understanding that its remedy was solely with ART. Indeed, the reinsurance agreements do not contain any cut-through provision and expressly disclaim third-party rights. In addition to being unsupported by the evidence on the record, Vantage's position was nonsensical. Why would the reinsurers agree to a comprehensive reinsurance program for ART through which they had bargained for rights, including the right to deny coverage if ART failed to provide timely notice of a claim and the right to arbitrate a dispute, only to voluntarily sacrifice those rights for the benefit of Vantage, a party with whom they had no relationship? Vantage's position is that the reinsurers essentially guaranteed any loss by Vantage, ignoring all written agreements to the contrary and in violation of DC statute of frauds. This highlights the lack of consideration.
Mr. Dodge, what do you think the court should do with respect to the negligent misrepresentation claim that was resolved on the basis of an unargued position?
Yes, Your Honor, the negligent misrepresentation claim was not brought against the reinsurers. That is a claim.
Thank you, I forgot that. Yeah, we'll deal with that later.
Yeah, that's right. That's next.
Yeah.
So, but I just want to, just point out this all highlights the lack of consideration for any implied contract as recognized by the district court. Vantage never paid anything directly to the reinsurers and never paid anything in extra support of an implied direct obligation running from the reinsurers to Vantage. The record soundly demonstrates that Willis and ART were not the reinsurers' agents. Undisputed testimony shows that ART and Willis Vermont did not sign or send to Vantage the binders on behalf of the reinsurers, and they in any event didn't have the authority to do so. And Vantage could not meet its burden to demonstrate that ART or Willis entities had any apparent authority to act on behalf of the reinsurers, because there was none. Because the agency theory fails, Vantage's promissory estoppel and unjust enrichment claims fail. And just want to point out, here for the first time, Vantage is calling, I think, the reinsurers these quota share insurers. Well, this is the first time. It's not in their pleadings. It's not in their summary judgment briefs. It's nowhere to be found in the record that there's any sort of insurance that was offered on a quota share basis by these 7 foreign-based reinsurers. And this goes, again, to the main theme of this, is just saying so doesn't make it so.
All right, Mr. Dodge, thank you. We'll hear from Mr. St. Genos.
And may it please the court. Good morning, Your Honors. May it please the court. Chris St. Genos on behalf of the Willis appellees. Your Honors, as my good friend Mr. Dodge noted over a decade ago, multiple sophisticated entities negotiated multiple contracts to put together a structure that was set up to wholesale distribute and resell natural gas and electric. Willis was not one of those entities. Vantage was formed to provide credit facilities to that structure as a risk offtake strategy. Vantage bought an insurance policy from ART, a DC licensed special purpose captive insurance company, and ART went out and bought reinsurance from the 7 appellee reinsurers. Again, Willis is not one of the insurers or reinsurers in this case. As my friend Mr. Dodge also noted, there was a loss, credit default. There was a fight between Vantage and ART over whether the ART policy covered that, and Vantage prevailed. When ART went to go collect from the reinsurers, it turned out that Mr. Palmer, the CEO of ART, and the individual Vantage calls the architect of the captive structure, had not provided proper notice as required by the reinsurance treaties, and so the claim was denied. Now, ART or Vantage, as was their right, could have gone to an arbitration to challenge that decision. Indeed, the treaties had an E&O provision in them designed to address just circumstances just like this. But instead, what Vantage did was it brought what the district court called were phantom contract claims, going around its insurer ART and suing the reinsurers directly. And Vantage also pursued an alternative route, as the district court said, leaping over ART to sue Willis and claiming that if Mr. Palmer's error actually resulted in a lack of reinsurance, it was somehow all Willis's fault. That is, it tried to make Willis the ultimate insurer in this case. Now, Willis Re of North America, Inc. was dismissed. There's no dispute, it's out. It was one of the 3 Willis appellees. The contract claims Vantage brought against Willis are out because there was no contract between those parties. They did not negotiate with each other, and no compensation was paid from Vantage to ART. What's left are tort claims, Your Honor. I think there really is no dispute that the professional negligence, negligent undertaking claims go out because, as the Court of Appeal in Washington, D.C. held, if it's a tort seeking economic injuries, as it is here, it's barred by the economic loss rule, subject to one limited exception if there's a special relationship. The case my friend Mr. Gibbons cites, Witt, actually sets the bar for what is or is not a special relationship, and they don't come close to meeting it here. For example, the Court of Appeal noted in Witt that the permit that was issued specifically directed the contractor to protect the hair salon. Over the course of 2 years, they had multiple conversations about protecting the hair salon. Here, Your Honor, Willis London had not one conversation or communication with Vantage. In fact, Vantage's CEO never even heard of Willis London. Willis Vermont sent one email noting a change of address when ART became ART. It had been called Vantage Re, and one phone call that Mr. Hamilton, the individual at Vantage who dealt with this, really didn't recall. That doesn't come close to the standard. The court asked about negligent misrepresentation. I think.
Counsel, was there any DC authority on whether the economic loss rule applies to negligent misrepresentation?
There is not, Your Honor. The 2 cases, and in full transparency, there were no cases one way or the other. After Aguilar in 2014, no case directly addressed whether it does or does not apply to negligent misrepresentation in all circumstances. Vantage cited one case, the Holmes case, which referenced it in a footnote, had nothing to do with whether the economic loss rule applies.
The district court didn't seem to acknowledge that. It seemed that the district court simply assumed sub silentio that the economic loss rule would apply to negligent misrepresentation as well.
Agreed, Your Honor. And there certainly are no cases that say it does not.
So what do we do under those circumstances?
I think, Your Honor, under the law of this court is entitled to uphold a decision of the district court if there is any ground that was argued before the district court that would permit this court to do so. There is, Your Honor, I think, if you look through the brief we put in, as well as the statement of undisputed material facts, and we don't have hundreds, I think we had 30 or 35, and you separate disputed contentions from disputed facts, I think it becomes clear, Your Honor, that the sole document they rely on for the misrepresentation claim, this binder in the joint appendix at 2677, it has the name of the captive, Vantage Re, now Art, on the top. It notes explicitly that Art is pleased to issue this binder of insurance. And the phrase they rely on in that document about reinsurance being ceded on the same terms and conditions was undisputably included by Mr. Palmer, the CEO of Art, because he had from the reinsurers binders, reinsurance binders, cover notes they're called there, that made clear it would be issued on the same terms and conditions. And Your Honors, so it's not lost, it was. The reinsurance follows the fortunes, follows the terms and conditions of the captive. They both required notice. The only reason there is no reinsurance here, if there is none, is because while Vantage followed the requirement of giving Art notice of these claims, Art, Mr. Palmer, failed to follow the exact same condition that was in the reinsurance treaties. This structure worked the way it was supposed to. Unfortunately, Mr. Palmer's error just ruined the insurance. Now, what was clear at the district court, Your Honor, was there was no facts. There was no law in Washington, D.C. that would permit Vantage to recover from Willis, Vermont, the captive manager, or Willis, London, the reinsurance broker for the captive, under D.C. law.
I'm not sure where that's taking you. Are you saying that the negligent misrepresentation just simply wasn't made out? That there wasn't the misrepresentation?
Under 552 of the restatement, Judge Ginsburg, they need to show a statement was made by Willis. There was not. They need to show the statement was false. They did not. And they need to show that the maker showed no due diligence. That's not the case. There was proof, and there's proof in the record that when Mr. Palmer made that statement in the binder, he had in his possession reinsurance statements from the reinsurers that said same terms, conditions, and settlements. They did not make out that claim. Your Honor, if you send this back to the district court, I believe the outcome would be the same, but this court is permitted to affirm the district court on that basis because it was briefed and argued below. Thank you very much, Your Honors. Unless you have any other questions, I'll submit on my papers.
All right, thank you. Mr. Gibbons, you can take no more than 2 minutes. Turn on your mic. You're muted, Mr. Gibbons. I can't hear you.
I was not.
All right.
I didn't
now
mute myself. That was the court. I think the court had muted me. Sorry about that. Your Honor, with respect to the term the quota share members, actually that was referenced in us in the earliest responses to the motion to dismiss. We cited it in our brief, and they're included in the appendix. Moreover, in the reply brief, we noted that the quota share members didn't have a problem with that term at all, and it was used throughout the depositions. In fact, the fundamental fact dispute here isn't whether it's a quota share. It's a quota share. They say it's quota share reinsurance. We say it's quota share insurance. The architect of this structure, who was their business partner, Paul Palmer, testified that the quota share members were the real insurers. PCC had no assets. It was licensed to do business in the District of Columbia. So it couldn't sell insurance except with the help of the quota share members who have assets but aren't licensed in the District of Columbia. They got together and sold this product. Mr. Palmer testified thoroughly that the quota share members agreed to pay on the same terms, conditions, and settlements. That was then signed by the COO of Willis. These are insurance binders. The entire structure and the premiums were all paid for that promise. Without the quota share members, Mr. Palmer testified and others that this would be not insurance. In fact, it would be a fraud. Moreover, the quota share members admitted that they were directly insuring Vantage. And I quote, there is only one deal on the books, EDF, which was what they called Vantage, selling electricity to resellers. We covered the default of these resellers in case of non-payment. That's direct insurance. That's not reinsurance. There are a number of these quotes throughout that this is throughout, and the district court recognized that the thrust.
All right,
of this
Mr.
case-
Gibbons, you're over your time, so
Oh, I'm
please
sorry,
wind it
Your
up.
Honor.
And Mr. Dodge, I wish you would quit shaking your head. Go ahead.
Thank you, Your Honor. I'm sorry, I was not looking at the clock.
All right, Madam Clerk, if you'd close court.
This honorable court is now adjourned until Wednesday, February 2nd at 9:30 a.m.